The European Union's internal market, also known as the EU single market, is a single market that seeks to guarantee the free movement of goods, capital, services, and people, the four freedoms between the EU's 28 member states. The internal market is intended to be conducive to increased competition, increased specialization, larger economies of scale. It is also intended to drive economic integration whereby the once separate economies of the member states become integrated within a single EU-wide economy. Half of the trade in goods within the EU is covered by legislation harmonized by the EU. The creation of the internal market as a seamless, single market is an ongoing process, with the integration of the service industry still containing gaps. It also has an increasing international element, with the market represented as one in international trade negotiations. The internal market has been extended to Iceland, Liechtenstein and Norway through the Agreement on the European Economic Area and to Switzerland through bilateral treaties. The EEA Agreement and the EU-Swiss treaties have exceptions, most notably on agriculture and fisheries. These four member states of the European Free Trade Association must accept all rules related to the internal market without being able to vote on them. History. Two of the original core objectives of the European Economic Community were the development of a common market offering free movement of goods, service, people and capital. Free movement of goods was established in principle through the customs union between its then 6 member states. However, the EEC struggled to enforce a single market due to the absence of strong decision-making structures. It was difficult to remove intangible barriers with mutual recognition of standards and common regulations due to protectionist attitudes. In the 1980s, when the economy of the EEC began to lag behind the rest of the developed world, the Delors Commission took the initiative to attempt to relaunch the common market, publishing a white paper in 1985 identifying 300 measures to be addressed in order to complete a single market. The white paper, which was well received and led to the adoption of the Single European Act, a treaty which reformed the decision-making mechanisms of the EEC and set a deadline of 31 December 1992 for the completion of a single market. In the end, it was launched on 1 January 1993. The new approach, pioneered by the Delors Commission, combined positive and negative integration, relying upon minimum rather than exhaustive harmonization. Negative integration consists of prohibitions imposed on member states of discriminatory behavior and other restrictive practices. Positive integration consists in approximation of laws and standards. Especially important in this respect is the adoption of harmonizing legislation under Article 114 of the TFEU. The Commission also relied upon the European Court of Justice's Cassis de Dijon jurisprudence, under which member states were obliged to recognize goods which had been legally produced in another member state, unless the member state could justify the restriction by reference to a mandatory requirement. Harmonization would only be used to overcome barriers created by trade restrictions which survived the Cassis mandatory requirements test, and to ensure essential standards where there was a risk of a race to the bottom. Thus, harmonization was largely used to ensure basic health and safety standards were met. By 1992 about 90% of the issues had been resolved, and in the same year the Maastricht Treaty set about to create an economic and monetary union as the next stage of integration. Work on freedom for services did take longer, and was the last freedom to be implemented, mainly through the Posting of Workers Directive and the Directive on Services in the Internal Market. In 1997, the Amsterdam Treaty abolished physical barriers across the internal market by incorporating the Schengen area within the competences of the EU. The Schengen Agreement implements the abolition of border controls between most member states, common rules on visas, and police and judicial cooperation. Even as the Lisbon Treaty came into force in 2009, however, some areas pertaining parts of the four freedoms had not yet been completely opened. Those, along with further work on the economic and monetary union, would see the EU move further to a European home market. Free movement of goods, customs duties and taxation. The European Union is also a customs union. This means that member states have removed customs barriers between themselves and introduced a common customs policy towards other countries. The overall purpose of the duties is to ensure normal conditions of competition and to remove all restrictions of a fiscal nature capable of hindering the free movement of goods within the common market. By agreement between the Union and the states concerned, Andorra, Monaco, San Marino and Turkey also participate in the EU Customs Union. Customs duties. Article 30 TFEU prohibits member states from levying any duties on goods crossing a border, both goods produced within the EU and those produced outside. Once a good has been imported into the EU from a third country and the appropriate customs duty paid, Article 29 TFEU dictates that it shall then be considered to be in free circulation between the member states. Neither the purpose of the charge, nor its name in domestic law, is relevant. Since the Single European Act, there can be no systematic customs controls at the borders of member states. The emphasis is on post-import audit controls and risk analysis. Physical controls of imports and exports now occur at traders' premises, rather than at the territorial borders. Charges having equivalent effect to customs duties. Article 30 of the TFEU prohibits not only customs duties but also charges having equivalent effect. The European Court of Justice defined charge having equivalent effect in Commission v. Italy. NY pecuniary charge, however small and whatever its designation and mode of application, which is imposed unilaterally on domestic or foreign goods by reason of the fact that they cross a frontier, and which is not a customs duty in the strict sense, constitutes a charge having equivalent effect, even if it is not imposed for the benefit of the state, is not discriminatory or protective in effect, and if the product on which the charge is imposed is not in competition with any domestic product. A charge is a customs duty if it is proportionate to the value of the goods. If it is proportionate to the quantity, it is a charge having equivalent effect to a customs duty. There are three exceptions to the prohibition on charges imposed when goods cross a border, listed in Case 1887 Commission v. Germany. A charge is not a customs duty or charge having equivalent effect if it relates to a general system of internal dues applied systematically and in accordance with the same criteria to domestic products and imported products alike. If it constitutes payment for a service in fact rendered to the economic operator of a sum in proportion to the service, or subject to certain conditions, if it attaches to inspections carried out to fulfill obligations imposed by union law. Taxation. Article 110 of the TFEU provides, no member state shall impose directly or indirectly on the products of other member states any internal taxation of any kind in excess of that imposed directly or indirectly on similar domestic products. Furthermore, no member state shall impose on the products of other member states any internal taxation of such a nature as to afford indirect protection to other products. In the taxation of rum case, the ECJ stated that the court has consistently held that the purpose of Article 90 EC, now Article 110, as a whole, is to ensure the free movement of goods between the member states under normal conditions of competition, by eliminating all forms of protection which might result from the application of discriminatory internal taxation against products from other member states, and to guarantee absolute neutrality of internal taxation as regards competition between domestic and imported products. Quantitative restrictions and measures having equivalent effect in addition to prohibiting customs duties and discriminatory taxes. The TFEU, in Article 34, prohibits quotas and measures having equivalent effect. But what are measures having equivalent effect and how do they affect trade between member states? In a well-known series of cases beginning with Dassenville, continuing with Cassis de Dijon and culminating in Keck and Mithoard, the court has said that discriminatory and non-discriminatory rules of member states that hinder intra-union trade, in the absence of a permissible justification, shall be illegal. Directly discriminatory rules distinguish between national and imported goods in law and in fact. A prohibition of imports imposed by State A on goods from State B is directly discriminatory, but restrictions do not have to take the shape of prohibitions or quotas. A member state can lead advertising and promoting campaigns that favors domestic products, or it can impose higher prices or more stringent conditions on imported goods. The key to discrimination is that domestic products are not subject to the added difficulties, and are therefore put at an advantage. Indirectly discriminatory rules that hinder trade do not distinguish in law but do so in fact. They impose a higher burden on the importer due to additional work it has to complete to make the product marketable. Although in law the rules apply equally to domestic producers and importers, in reality the burden is borne by importers. The domestic producers already complying with the rules. If, in addition, the product is marketed in a number of member states, the exporter from State A might be subject to as many different regimes as there are countries into which he is hoping to import. For example, a law in State A is that alcoholic drinks of a particular kind must not contain more than 20% alcohol. Producer from State B makes and regularly exports drinks which contain 25% alcohol. Law in State A applies to all those who wish to market the alcoholic drinks in question, whether they are domestic in origin or foreign. In that respect, in law, they do not discriminate. On the other hand, as a result of their presence, a legally marketed drink from State B either has to be modified and its alcohol contents reduced to only 20% or must be absent from the marketed State A altogether. EU law, under the circumstances mentioned in the previous paragraph, prohibits this kind of distinction. Although the law appears to treat all parties equally, in fact domestic producers are favored. Product requirements and certain selling arrangements. Naturally, allegations can be made against any rule that inconveniences the trader, and this includes a very large number of rules. Therefore, in the last of the mentioned cases, Keck, and those that followed it, the court decided that only rules relating to product requirements should be illegal, while those relating to selling arrangements will mostly not be. The division was an attempt to limit the number of cases to only those situations where, in the absence of discrimination, there is real danger of importers suffering the presence of dual burden. Justification. Under certain circumstances, member states whose rules have been disapplied may defend them. For rules that discriminate, a defense will be possible under Article 36, which mentions, among other grounds for prohibition or restriction of free movement, public morality, public policy, public security, protection of health, etc. For example, a national restriction of import of meat from certain countries will be justified, though deemed contrary to free movement rules, if the member state can justify it by proving that it was necessary for the protection of health and life of humans. A restriction of importation of pornographic material may be justified on the grounds of public morality, if such material is normally illegal in the said member state. Non-discriminatory rules may be justified not only by reference to Article 36 but also to a court-made list of exceptions which were first set out in the Cassis de Dijon case, and are commonly referred to as mandatory requirements. Free movement of capital. Free movement of capital is intended to permit movement of investments such as property purchases and buying of shares between countries. Until the drive towards economic and monetary union, the development of the capital provisions had been slow. Post-Maastricht, there has been a rapidly developing corpus of ECJ judgments regarding this initially neglected freedom. The free movement of capital is unique in that it is a goal of the EU to pursue a liberal capital regime with third countries. Capital within the EU may be transferred in any amount from one country to another. All intra-EU transfers in euro are considered as domestic payments and bear the corresponding domestic transfer costs. This includes all member states of the EU, even those outside the eurozone, providing the transactions are carried out in euro. Credit, debit card charging and ATM withdrawals within the eurozone are also charged as domestic. However, paper-based payment orders, like checks, have not been standardized, so these are still domestic-based. The ECB has also set up a clearing system, Target, for large euro transactions. Free movement of services. The free movement of services and of establishment allows self-employed persons to move between member states in order to provide services on the temporary or permanent basis. While services account for between 60 and 70% of GDP, legislation in the area is not as developed as in other areas. This lacuna has been addressed by the recently passed Directive on Services in the Internal Market, which aims to liberalize the cross-border provision of services. According to the treaty, the provision of services is a residual freedom that only applies if no other freedom is being exercised. The free movement of services is established in Article 56 TFEU, with further guidance in Article 5762 TFEU. Exceptions are found in Articles 5155 TFEU. The freedom prohibits restrictions on free circulation of services within member states. Services are defined in the negative. They are normally provided for remuneration, insofar as they are not governed by the provisions relating to freedom of movement for goods, capital and persons. The services are distinguished from freedom of establishment based on their temporary rather than permanent nature, and from free movement of workers based on the fact that the freedom affects corporate entities and individuals outside of the relationship of employment. Chapter 3 of Title IV applies to services as long as either the service moves across the border, or the provider moves, or the service itself moves. The Court has recognized that the obstacles to freedom to provide services may arise both from discriminatory and indistinctly applicable rules. Two directives are also of particular relevance: the Posting of Workers Directive, sometimes referred to as the Posted Workers Directive, and the Directive on Services in the Internal Market. Freedom of establishment. The principle of the freedom of establishment has a basis in Articles 49 to 55 of the TFEU. To better understand the freedom of establishment, Article 49 and Article 54 tend to be read together. According to Article 49, restrictions on the freedom of establishment of nationals of a member state in the territory of another member state shall be prohibited. Freedom of establishment shall include the right to take up and pursue activities as self-employed persons and to set up and manage undertakings, in particular companies or firms within the meaning of the second paragraph of Article 54. This second paragraph defines companies or firms as companies or firms constituted under civil or commercial law, including cooperative societies, and other legal persons governed by public or private law, save for those which are non-profit making. The right of establishment, therefore, is granted both to natural and legal persons. The principle has been broadly interpreted by the European Court of Justice. However, its restrictions have been narrowly and literally interpreted. For example, in the case of Reyners, the European Court of Justice held that the exceptions allowed by the first paragraph cannot be given a scope which would exceed the objective for which this exemption clause was inserted. The teeth of this principle is that natural persons, who are nationals of a member state, and community companies may take up economic activity in any member state in a stable and continuous way and cannot be discriminated against based on nationality or the mode of incorporation. Digital Single Market. In May 2015, the Juncker Commission announced the plan to reverse the fragmentation of Internet shopping and other online services by establishing a single digital market that would cover digital services and goods from e-commerce to parcel delivery rates, uniform telecoms and copyright rules.